Hey, class, I hope you're having a good Friday or weekend. We have a test coming up Monday or Tuesday. So I'm sure you're working hard to prepare for that. So I put together a study guide, but I figure I'd do a video too, just to kind of walk you guys through things. Also, at the end of the video, I will give you the answers to your Chapter 6 review assignment. That way you have those and can study for that, or use that as a study guide as well. So, chapter 5 and 6, we covered a lot of material. So, in chapter 5, we started by discussing torts. So, as a reminder, a tort is an offense against an individual. A term you need to know is the master servant rule. So, the master is the employer. Um, as we discussed in class, it can also be a parent. It depends on who the servant is. So, employer if it's an employee, parent if it's a kid, or a kid would be the servant. Most torts have to have the four elements in order to prove them. So, duty, breach of duty, injury, and causation. Uh, Duty is you have the duty to respect the others, a duty not to injure others physically, their property, their reputation, or invade their privacy. Duty not to interfere with property rights, and duty not to interfere with contractual or economic rights. So your breach of duty is when a person doesn't live up to those standards. So another term to know is the doctrine of res loquitur. It allows court to presume without showing proof a violation of duty, as the accident would not have occurred without it. So again, this is an example of a piano falling on or off the building. It doesn't necessarily have to be intentional, but it happened due to a careless act. An intentional tort would mean you actually intended to harm the person. Negligence would be a little different. So you would just be neglected or careless of the defendant. And then strict liability is a person acted in a certain extremely hazardous way, not intent or carelessness. So it would be like if you're walking your dog and your dog bit someone. Or in my case, you're out with a walk on your kid or with your kids and they go crazy and do something careless, that strict liability falls back on the person. You have to prove injury. Obviously, no injury, no tort, and causation. So the breach of duty caused injury. Remember the term proximate cause, which is when it is reasonably foreseeable that a breach of duty will result in injury. Also, the term liability. So all people are held liable for their own conduct. This does include children and the insane. Remember, respondent superior, employer held liable for their employee. So we kind of went through that when we talked about white collar crimes last chapter. And then we're going to go through the whole list of intentional torts. So remember the difference between all of these. You guys did a great job acting them out in class, so you should remember kind of those skits. But let's kind of just briefly go over them so you remember what they are. So an assault is with words or gestures that are meant to cause immediate injury. So that would include sexual touching, sexual harassment, has to be believable, and the ability to carry it out. So assault is different than battery. So a lot of you guys on this quiz got these two flipped. So battery is the actual touching. So that's the actual physical contact that caused harm. Assault is gestures and verbal. Assault and battery can occur separately or together. So remember, if you threaten someone and then you actually do it, then that would be assault and battery. That's not battery if it's not on purpose. So if I accidentally bumped into you in the hallway, would not be considered battery. If it's in self-defense, it's not considered battery. And remember, it's defensible in court if there's an assumption of risking contact. So if you're playing football, you're boxing, whatever, you're not going to be able to use battery in court. False imprisonment is the intentional confinement of a person against their will. This is handcuffing a person, tying a person up, Threatening a person that if they leave, you're going to do harm to them is also considered false imprisonment. It's not false imprisonment when you give consent. It's also not false imprisonment if like a police officer has reasonable, they think you're going to commit a crime, so probable cause, they can confine you. Next one is defamation, which is when you make a false statement about a person's reputation, slander if spoken, libel if written. Remember that defamation is a really hard tort to prove in court, right? Because you have to prove it's false. So again, my analogy is if you call me a jerk, I'd have to prove that I'm not a jerk. It has to be communicated to a third party, and it has to bring the victim disrepute, contempt, or ridicule by others. Again, it's just really, really hard to prove those things. Invasion of privacy. So this is a tort defined as uninvited intrusion into an individual's relationship and activities in a way that causes them shame or mental suffering. So publication of even a true statement by someone could be invasion of privacy. Privacy includes the freedom from commercial exploitation of one's name, picture, endorsement without permission. So this bans illegal eavesdropping. Police aren't allowed to tap your phone lines or anything unless they have a warrant. And then when you're a public figure, if you're a politician or actor or someone in the news, you kind of give up that right to privacy, right? Because you're always in the spotlight. You're always going to kind of expect it. So you don't have the rights as a famous person as someone like us would have. They get the money, but they don't get the privacy. So you kind of have to guess which one you prefer. So the intentional infliction of emotional distress, this is the one that requires an intentional or reckless act by the defendant so outrageous or extreme it causes suffering of emotional distress. So remember, this was the story I told about the lady in California who was walking her dog and then someone came out with a baseball bat and beat it to death. So this lady sued and got $50,000, and the reason she got that money was this reason: the intentional infliction of emotional distress. Sad story. I mean, obviously, obviously that's pretty upsetting. So she probably deserved the money, but is $50,000 really going to make up for your dog? Probably not. Trespassing, the entry onto the property of another without the owner's consent. Intent has to be required. So remember, if you're throwing the baseball around with your friend and you're throwing the baseball around with your friend and it goes into someone's yard and you go get it, that's not really trespassing. Conversion is one we talked about kind of in detail. So it's a person's property that is stolen, destroyed, or used in a manner inconsistent with the owner's wishes. So a person doesn't need to know in conversion. So for a criminal activity, the person needs to know it was stolen in order to be convicted. For a conversion and a tort, they do not. So the innocent buyer and the actual thief are both converters in this case. Fraud is recklessly made misrepresentation of a fact and facts that were relied on. So in order to recover from fraud, you need to not be able to check the truth by exercising due diligence. So if you something like you see an ad on Facebook and you believe it, so like political ad like Trump bit off a dog's head and someone said vote Biden for that reason, then obviously you're just not doing due diligence to check that that's not true. Opinion statements are also not fraud. So if you're reading a paper and someone is writing about something and it's their opinion, you can disagree with it, but it's not necessarily fraud. Next is negligence. And this is the most common kind of tort. All right. So you look at 4 elements of negligence. The first one is duty imposed by negligence. So you look at the reasonable person standard. The standard requires that you act with care, prudence, and good judgment of a reasonable person so as not caused injury to others. different ages and professions have different degrees of negligence. For example, children under 7 are incapable of negligent conduct. Children 7 to 14 are reasonable for children that age. But say that a child does something extremely reckless, like steals a car, drives it into a building, and that child can actually be held liable of that tort and get charged with negligence. Same thing with professionals. If you work in a certain field, you're going to be held to a higher degree than others. So obviously, police officers are, and we see that right now with the whole Black Lives, Blue Lives Matter thing, where people are arguing that police officers need to be held to a higher standard. I'm a teacher, so if something happens to you guys in my classroom, then that would fall back on me, and I'd be held at a higher standard than, say, maybe a substitute teacher or something like that. Number 2 is breach of duty. So again, reasonable person standard. Breach of duty would occur when one person has a duty of care but failed to live up to it. And then you look at, so breach of duty, you would look at the analogy of the sober driver, right? So you're driving at night, the lights are on, you're awake, everything's good, you're going the speed limit. You're not going to be charged with negligence because you're doing the right thing. So when we get down to causation and injury, so the violation of duty must be proximate to the cause of injury. So if you were speeding and intoxicated and it was foreseeable that such conduct was going to happen, then you're guilty of breach of duty, causation, and injury. So if you're defending negligence, you have a few different cases you can look at. So in several states, the plaintiff cannot recover a loss caused by another if the plaintiff was also negligent. So if we were doing something bad, if we were drinking together, we got in the car together, we wrecked, even though I'm a passenger and got hurt, I would still not get anything from a tort or be able to sue you because I was also negligent. I made the poor choice. Most states have comparative negligence, which applies when a plaintiff in a negligent action is partially at fault. So remember, it's kind of like if 2080, I would get some, but I'm not going to get all of the award because I was still partially at fault in this. And then assumption of risk. So if you're doing something that is crazy, if you're running with a rifle, you're practicing your target practice, you're just doing something that isn't wise, then you fall back on the assumption of risk of knowing that you knew it wasn't wise and that you're not going to get anything from your actions. This kind of goes with strict liability. So a defendant can be held liable if he or she merely engaged in a particular activity resulting in injury, regardless of whether he or she was not negligent. So only apply to someone that has engaged in an abnormally, add that in there, be proper, abnormally dangerous activity. Something like owning dangerous animals. Obviously, you're owning dangerous animals. You know that they could get out and bite someone. Another thing would be selling unreasonably dangerous goods. And again, remember the statutes of repose, which is important. So if something has been around and created normally 10 to 12 years, you're not able to sue for negligence after that because the statute of repose keeps you from doing so. So we move on to the civil procedure. Let me get a drink. So this is a long study guide. So there's 2 types of remedies in a civil procedure. You have injunctions, which is the court orders a person not to do something. So simply a court stepping in, slapping you on the wrist, saying you do it again, and you're going to have more severe consequences. Those consequences normally come in as damages. So there's compensatory, which think of this as if you were fired for something and it wasn't right, that the judge will put you back in your same position. And then punitive, this is typically awarded in most intentional courts or in tort cases. It punishes a person. Normally, that is financially, where you have to pay the person that you injured. Another thing to look at, we kind of talked in class this week, were lawyer fees, right? So before you sue someone, before you take them to court for a civil case, you have to look at how much it is. So lawyers charge in two ways. They charge hourly. That's typically $200 to $300, depending on where you're at, per hour on average for a lawyer. They make good money. Lawyers make good money. Or contingency fee based. So if you win and you settle before the trial, the attorney will take 25% of the winnings. If they won at the trial, 33, and then if you appeal it and they win, then they get 40% of your winnings. And it kind of makes sense because, right, if you settle before the trial, it's less work. At the trial, it's more work, and then obviously if you have to appeal it, then they're doing way more work. So again, you have to make sure that what you're doing is worth it and that you're going to get enough from it to make it worth suing. So again, if you're upset over a $900 wheelchair, is it worth going to court over? Probably not. Probably just have to suck it up a little bit. Then the procedures of a civil court case are kind of similar to those of a criminal case. So you have the plaintiff, which is the one who files the complaint. The defendant is the one who is filed against. The complaint is the actual legal document. The summons is served with the complaint, which basically demands that the defendant comes to court to answer. Answers are done through lawyers. If you don't answer in a timely fashion, then the judge can basically just make a ruling on that. And then there's discovery. So there's two types. There's the depositions, which is the in-person, under oath. You have to answer questions, and everything you say is going to be heard by the jury or the judge. And then interrogatories are a list of questions, kind of just questions that the opposing lawyer wants to know. So both sets of lawyers send it to the other lawyers to give to their clients. They and the clients fill it out, and then they send it back to the other attorneys. These can sometimes be used to help make deposition questions. More than likely, they'll be used somewhere in the trial. So that is discovery. We talked about judge and jury trials, right? So if it's a jury, they decide the fact or the issues of facts. Judges decide the issues of law. So it's just like a criminal trial, right? The jury is listening to all the facts and trying to come up with their conclusion, while the judge monitors the courtroom and makes sure that everyone is doing things that are legal. Sometimes there's no jury, and if that's the case, then the judge decides both the law and the facts. Civil juries are a little different. So they are made up of either 6 to 12 citizens. Most states' juries do not have to have a unanimous verdict. So in these, it's normally 5 of 6. If it's a 6-person jury, if it's a 12, it's 10 of the 12 have to decide. We'll go over this briefly because it's very similar to criminal. So you have the opening testimonies, statements and testimony. So attorneys make the opening statements. They present the evidence on both sides. They do their closing arguments to make one last stance. The jury gets instructions from the judge. They deliberate. Like I said, it's 10 of 12. If it's a 12-person, 5 of 6 have to agree. If it's a 6-person jury, verdict is the jury decision. The judgment is the final result. And remember the writ of execution. So this is the judge will issue an order if the defendant fails to pay after a judgment becomes final. So then in chapter 6, we discussed contract law, right? So contract law is the agreement of 2 or more parties. There's 6 major components that make something legally binding. So first, you have to have the offer and the acceptance. So the offerer is the one making the offeree, the one who the offer is made to. The terms must be accepted without change. Remember, if you change it, it's a new offer. It has to be accepted by both parties as intended. The second is genuine assent. So it's basically not deceiving another, making sure that both parties know all the facts and that it's not under duress. Legality, you can't make a contract for something that's illegal. Consideration is something that both parties have to give, right? You have to take some time to think about it. Capacity, must be able to enter into a contract. So you look at this like no minors. If you're under 18, normally can't enter a contract. If you're mentally incapable of entering a contract, then you can't do it. And you have to be in a good state of mind, right? You can't be high, can't be drunk, have to be sober when you're entering a contract. Not all contracts have to be in writing. The ones that do are real estate, agreeing to pay for someone else's debt, contracts longer than a year, contracts over a certain amount, which varies by state, and then a transfer of property and death. 2 classifications you are definitely going to need to know. Unilateral, which is a promise made by one party in exchange for the performance of some act by another party. Think of this as the lost dog scenario. Bilateral is an agreement formed by the exchange of a promise in which a promise by one party is consideration and supporting a promise of another one. So remember the video, the girl paid the guy $100 to paint her fence. He agreed, so he painted the fence and got the $100. Then we look at offers themselves. So the definition of an offer is proposal to do something provided the offeree does or does not do something in return. So there are 3 steps in the offer. First is contractual intent must be present. So it's not a joke. It's not made in extreme terror or anger. Preliminary negotiations are merely that, preliminary negotiations. They're trying to induce someone into negotiating. So store windows, TV, newspaper ads, a salesperson coming up to talk to you. The commercials that we watch for the most part are all preliminary negotiations. And then social agreement and arrangements. You typically can't sue if you break a date. And these do not typically create legal agreements. You have to communicate the offer. And number 2, right? The offeree has to know what the offer is. The person cannot accept an offer that she doesn't know about. So pretty easy stuff there. Terms must be complete or definite. So if they're complete, you know the price, the subject, the quantity. Real estate are obviously way more detailed. Definite are the essential terms must be identified clearly. So remember when we were doing all those critical thinking things, a lot of the answers were we just didn't have the complete information, so they couldn't enter into or they couldn't accept the offer. So when you're making an offer, make sure that all the details are there for it to be valid. So there are ways to terminate an offer, which is what we went over Wednesday and Thursday, right? So revocation basically means the offer just wants to reject it. This is good anytime before the offer is accepted. Time stated in the offer. So if there's something in the writing, I have to receive it no later than this date. Then if it's after that date, offer is voided. Reasonable length of time, which is if the time's not statable, then is it reasonable? So if it's for like perishable goods, obviously it's going to be like a week or 2. If it's seasonal, if you're making an offer for Christmas and it's Christmas has gone by and it's February, obviously the offer would be non-void. Rejection by the offeree. It's just the offeree doesn't want the offer anymore and takes it off the table. Counter offer is one where you want new terms, right? So you like the offer, but you want to change some things. And as soon as you do that, it gets rejected and becomes a counter offer, which basically becomes your new offer. Death or legal insanity. A lot of you guys in both classes had great scenarios for this, but yeah, if you die, then the offer's done. If something happens and you are found to be legally insane, the offer's done. And then destruction of the subject, right? So if you're making an offer on a new car and the car catches on fire, then the offer's done. So if you want to keep an offer open, one of the ways to do that is looking at options. So say you're going to that you want to buy a car, but you're not there. You can like pay the person $1,500 to hold the car for a few days until you get there and are able to look at it. So what this will do is keep them from selling that car from under you. Now, if you get there and you don't like the car, do you have to buy it? No, but you might lose that $1,500. Firm offers are something that mainly from company to company, or as we call merchants, right? So merchants are held to higher standards because they buy and sell goods on a regular basis. Firm offers are written offers that contain a statement that the offer will stay open. So the Uniform Commercial Code makes offers binding for the time stated, but not more than 3 months. Finally, we look at acceptance and what's required for that. So acceptance occurs when the offeree accepts the proposal. It must come from the person, must match the terms. And we have to remember the mirror image rule, right? The acceptance must exactly match the offer for an agreement to be legally effective. It needs to be communicated to the offerer. So failure to respond at all to the offer cannot be construed as an accepted offer, right? So if you like it, you agree to it, have to communicate with the person that made the offer. Those modes of communication vary. So contractual communication such as offers, acceptance, rejections, revocations, counteroffers can be generated or communicated in person or by other means. Those other means would include telephone, texting, fax, mail, email, delivery service, etc. Most of the time, you have to have a signature, especially on your bigger contracts. And that is that. So that is a rundown. Everything on the test will be somewhere in the study guide. The study guide is not going to be used on the test. So study it this weekend, kind of get a good feel for things. And like I promised, I said I would go down the answers for Chapter 6 review that you guys just did on Wednesday or Thursday. I'm not going to read the answers. I will just go down the answer list. So number 1 is true. 2, false. 3, true. 4, true. 5, false. 6, true. 7, false. 8, true. 9, false. 10, false. And then on the back side, or the second page, 11 is A, 12C, 13D, 14D, 15B, as in boy, 16A, 17C, 18A, 19B, 20D. All right, so I am going to post the actual study guide as a document so you guys can look over it. If you have any specific questions, feel free to shoot me a remind message. Shoot me a message on Canvas, and I'll be glad to help you out however I can. If not, I will see you in class Monday or Tuesday, ready for the test. Have a good weekend.